first of all, one of the points that was made last night in some discussions about this, public discussions about this, was that, she's young, this is her first crime, that there's no way that a jury's going to convict her of death. But I can think of at least one case that's similar, not exactly the same, where a young man burned his girlfriend to death. And this was his first crime, and he was young, but they sentenced him to death. So talk about that theory that people are floating, that there's no way a jury would ever decide the death penalty.
Well, in the first instance, you can never say never. The jury will hear all of the particular facts of this case. They will hear all the aggravating circumstances in support of the death penalty and the unlimited mitigated factors weighing against the death penalty. But because of the nature of this act, no, I would not say that it's an impossible task to get a death sentence based upon these circumstances that we now know surrounded the death of that child, especially since we have the added aggravated factor of the person having committed the crime who stood in a familial relationship with the child, in this case, the child's mother.
So, and that's another issue. And see, last year, that was a new aggravator that was added under the law that would actually, people think that it's not going to happen when it's in a familial situation. But that aggravator was just added last year. It seems like the lawmakers want to get tougher in those situations and not cut people a break if it's a family member. Is that
absolutely right? That now is an aggravator that works against mitigating that, well, it was a family member and therefore we should give them some pass on this, or that is somehow a mitigating circumstance. It is now specifically an enumerated aggravating circumstances. They're going to take all of that, by the way, and what's going to make it relevant, a lot of these photographs, lifestyle photographs and things that you see that won't come into the guilt phase of this trial will absolutely come into the penalty phase of this trial, and this jury can certainly be painted a picture of a self-centered, selfish young lady who wanted this child that she viewed as nothing more than an impediment removed from her life. So if there is a case of a young mother that may in fact receive the death penalty, it would be this case.
And not only did she want her out of the way, but it almost looked like she was celebrating. I mean, those pictures, now that you're bringing that up, it almost looked like she was celebrating. Like somebody even, I know that I've heard this in discussions from, I guess, psychologists, that the dancing on the grave idea, that concept, that is not uncommon in certain situations where they want someone out of their lives, and once that person is out of their lives, they're happy, they're free in their minds. And is that what you would think, that they would use those pictures?
Absolutely. The state will have a forensic psychologist or forensic psychiatrist to evaluate what we're seeing of these partying photographs after the disappearance, and we now know death of that child, and that is going to be very powerful in the jury's mind to in fact take away any sympathy that they may have for her and go back to the letter of the law and weigh those aggravating circumstances and say, you know what, the mitigators don't outweigh the aggravators in this case, and we believe that death is appropriate. And understand, you don't have to have 12. All 12 vote for death. All you have to have is the majority voting for death.
Right. The adding that new aggravator, that if the person was vulnerable, do you think that's what that was aimed at? Because in the past, people have gone a little easy in many people's minds on someone, as if it's any less egregious because it was your own child?
Absolutely. Because there has been, if you think historically, we've not seen as many of these types of crimes where parents are killing children, children are killing parents, or and vice versa. And because it is now almost an everyday occurrence somewhere in the country, Florida, who is very, very conservative, said, you know what, that deserves special consideration in aggravation of the sentence that will be imposed, and we want to make it statutorily so a jury's instructed that this is a aggravator. Not in any sense can you use this in sympathy and as a mitigator.
And can you explain that again in terms, without using the legal terms of aggravator and mitigator, just your view, lawmakers adding that aggravator of that vulnerability or familial relationship, what do you think that lawmakers are telling jurors? Is that a message? We're not going to go easy on this anymore. We don't want to go easy. What message is
absolutely
that?
Historically, when you see legislation like this that involves sentencing or criminal procedure, it usually comes about because there was some perceived defense abuse of in this case, the fact that it was a mother who killed a child. And so in order to send the message and in order to make sure that the defense doesn't get to use that, they then enact this aggravating circumstance that says, you know what, you deserve to be punished more harshly if you stood in a familiar relationship. And it only makes sense because the child looks to the parent to protect them from all of the harms of society, and the one person that the child looks to betrays them and kills them and does them harm. Can there be a more aggravating circumstance? And in my mind, I really can't think of a more aggravating circumstance.